Okay, it's about 8:34 p.m. Central Standard Time. Today is Monday, August 16th, 2021. And welcome to week two of business law. And for those who should chime in, I should let you know I'll put in here in the chat box. Okay, activate audio to hear the lecture. Okay, and let's enter that. All right. So uh, it is very important that students learn how to navigate this system in order to hear the lecture. So I always remind students at the beginning to activate audio. Um, and it's right up at the top, and it tells you how to do it. I see that the student is in twice, and they need to come out on one of them because I see Willie Lacey 2 times. So activate audio and not. Anyway, I'm going to go ahead and get started. Okay, I see he's got one of them. Okay, so you can delete that Willie Lacey that doesn't have a microphone next to it, so that you'll only be in there once. Otherwise, you're gonna get some feedback from yourself there on your end. So anyway, I'm going to go ahead and uh, first of all remind people that our lectures from this point on are every Monday night, and that will be including Labor Day, and it will be at 8:30 p.m. Central Standard Time. A few people thought that I was having lectures this morning like I did last Friday, but I announced last week, and then the announcement that I had posted just a few minutes ago uh, reminded everybody. But the calendar is always the place because that's already set, and it tells you when everything is taking place uh, as well. All right, so I'm going to go ahead and share my screen. All right, there we go. Very good. So now we're all set to roll. All right, share this. We'll come back to that in a minute. Move this up here. Let's do student preview for right now. Okay, so I'm not going to go over all the stuff I went over last week. If you do want to find out some information about the system, you want to check it next week. Okay, not next week. You can go back and look at the recording. And I had one student that asked me, was there a key phrase given in week one? Yes, there was. Did you guys find the key phrase for week one? You can type in the chat box and I'll see that. Yep. Okay. Okay. I see Mackenzie. Willie, did you find it? Okay, good. Because there were some students that said to me, I didn't get it. And I'm not going to say what it was, but I do say what it is quite a bit. But anyway, um, the key thing everybody should remember is listen to the entire lecture. Don't just look at the lecture to get the key phrase, because I give some cogent information to help you, especially in that week one lecture. All right. And so week two, first of all, before I do that, you can check your messages over here, and the link to week one is in here. And then also, I haven't sent it, but the PowerPoints, I'm going to send that right after we finish this. And so you'll have the PowerPoints for week 1 as well. The grade book, and it tells we have discussion post this week, a written assignment, and live lecture as we did last week. So let's look at the discussion posts for this week. As you've learned, the discussion posts for initial posts are due tomorrow night, which is Tuesday the 17th, and your reply posts are due on Saturday. That's the way it's going to be all the way from weeks 2, 3, 4, and 5. Once we get to week 6, the discussion posts for initial posts will be due that Tuesday, but the reply posts will be due that Friday. But you don't have to worry about that for a few more weeks. So anyway, let's talk about the topic today: consumer contracts. There's our business world is run by contracts, and we'll talk a little bit about that in a few minutes, but I'm just going to go ahead and give you the assignment information now. Contract law consists of many factors, and they don't just affect organizations, they affect the lives of every consumer in every way. Did you not know that even when you make a purchase, you use your debit card, credit card, or either a check, you are entering into a contract, and so you're agreeing to pay for the item that you purchase or items. So there's a wide variety of areas that cover it, and we'll talk about the details. So what I want you to do is research the topic of consumer contracts, and then what are some of the examples of frequent or regular agreements that both individuals and business enter. Well, we're going to talk about that in just a few minutes. Also, when you do your readings, you'll be able to see what that is as well as the PowerPoints. So in your initial post, you're going to present an example of a possible agreement that may involve organizations or individuals. Possibilities include leases, actually mortgages, phone, internet contracts, and even receipts. I told you that a few minutes ago. In your analysis, explain what elements need to exist for a valid enforceable contract to be in place. In your contract reply post, you're going to respond to at least one other classmates. You consider the elements they offer. Do you agree or disagree with their interpretation? Why not? This is places you can find information about library research. We shared that last week as well. So then you'll type in your response and then your reply post. All right, so that's pretty straightforward. Again, more clarity will come as we go over tonight's lecture and the details. Your written assignment for the week. Let's look at the assessment. So you have a scenario here. So you're going to prepare a PowerPoint presentation. Now, as I said before, there will be times when you will see a Word document, but last week's assignment was a PowerPoint presentation as well as this. I had a student to ask me if they had access to PowerPoint, and the answer is yes. You should. When you came into the school, you have been given a free version of Office, which contains PowerPoint, Word, and I believe Publisher, but you won't use Publisher that much. But Word is what you use, and then PowerPoints for your assignments, how to set up your PowerPoint. So you're going to follow these instructions. Title your slide, introduction, with an overview of your business and the purpose of the presentation. And then 3 to 5 slides that address the legal points Okay, and you're going to hit each of these bullet points in here. Make sure you have references as the last slide in the presentation. But also, I'm going to remind you, because I operate on APA, that in the body of the actual slides, provide the source as a citation as well. So, and it tells you uh, how to deal with PowerPoints, how to deal with APA, and also how, if you want to get some help, that I talked about last week. In a few minutes, I'm going to go back and show you the rubric, which is always so important. So we'll go there in a minute. And then, of course, the last thing is the live classroom, which we're in now. And you're going to have a key phrase, which you'll have until Sunday. So you'll have till Sunday to do the assignment and the live classroom lecture. And then your discussion assignment, as I said, it says 21st, but that's the reply post. Your initial post, as I said, and you'll see it in a minute in the calendar. Okay, so now let's go to let's get out of that. Let's go to the rubric. All right, here we go. This is the full rubric. As you can see, there are 4 sections to it. And the key one that I want you to follow is the one on the left. They got adequate, but it shouldn't be adequate. This should be changed, but that's how they set it up. I know why they did this like this, because it's a new setup that they did. So it'll be adjusted, but actually this one should be excellence. This one should be, I forgot what the next one, this one would be competence, and then emerging. But let me put it this way. You see the points decrease because you didn't provide certain things. So what I tell my students, always focus on the highest column. Even though the other columns are there, I would try to get you to start to ignore them. If I could, I would delete them, but they don't want me to do that. When I do my own PowerPoint, I don't put those in there like that. I just put the one that I want you to do. So my point is, start out by satisfying the requirements on the one on the left. Thorough and detailed explanation of the basic elements for each contract. Thorough and detailed explanation of commonly used clauses. You'll learn all that tonight and in your readings and in your PowerPoints. Exemplary recommendations for how to proceed with contracts, and then your format with APA and in-text citations and references. Remember, I talked about that earlier. So you make sure you satisfy that. Very, very, very important. Students will leave out the in-text citations, and you'll end up over and emerging every time. I'm telling you this. That happened to a few people, I'm sure. I haven't graded them yet, but I'm going to start grading them. I plan to have all your assignments graded by no later than Friday night at 11:59 p.m. Central Standard Time. Any questions about the assignment business contract recommendations? Any questions? Okay. All right. So again, it's pretty straightforward, but you know the parameters about reaching me and how to reach me. I've had a few students to reach me at Sunday night at about 10 o'clock at night and tell me that they need an extension. Um, I won't generally do that. I won't do that. And the reason why is because, well, we did have a shorter week last week. However, especially going forward, because you're getting your information the first day of the class week, which is Monday. And so I'm not going to be as forgiving in weeks to come in terms of that. There's a few people who said that things happened to them on Sunday. Well, that's because they waited till Sunday to do it. But once again, with the lecture having been Friday, um, so they had one day. So I'll be kind of how should I say, liberal with giving extensions for week 1. But that's on be all off for week 2. If you need to reach me earlier in the week and get the reading and done, and then look at the PowerPoints and listen to the lecture. All right. As I said many times, the best way is to come to the live lecture, and then you'll be able to ask questions contemporaneously with the lecture itself. All right. So now let's go back. All right, and let's look at, okay, we already did discussions. So let's look at the calendar before we go into the material. So I like the month view, and you can see this is where we are. The 16th live lecture, and it tells you the time. Your initial post is due tomorrow. Your reply post is due Saturday. Your written assignment is due Sunday. And then your live classroom phrase. As simple as that. This classroom lecture, if you were to click on it, it would take you to tell you where the link is. Of course, you guys that are here don't need to know that, because you already know that. That's how you got here. Okay. So, but anyway, now be aware that, let me move this a minute. So the month. So let's go to showing you how this thing operates. Class ends the 17th, as I said earlier. And if you notice what I said, all the way down to this, everything is the same, except the last day, the last week's assignments are all due the 17th. The course absolutely ends on the 17th, not the 18th, not the 19th, or the 20th. I'll say that every week, and I guarantee you that I'll have people that come and at the end and say, oh, I thought it was ending that Sunday after. That's not true. All right. That means they didn't pay attention to the lecture. So let's get into, we discussed the discussion, the assignment, written assignment, the live classroom. Again, this is another place where you go ahead and you add your points, and then you'll get 5 points for having it in on time. All right. And then where you can find the link, you go here, and right now here is the link. Again, I won't click on that because it will open up a double in the classroom, because I'm already here, you already here. But at the end, I delete this and put the link to the recording that we are currently doing right now, and then convert it to a YouTube, and you'll be able to have access to that by the end of tonight. So we're going to talk about these 4 things: basic contract elements, illegal, defective, and contracts between partnerships, for roughly the next probably 40 minutes or so, close to that. So let's look at contracts themselves. So written contracts are a bit safer than oral contracts. Now, I'm going to provide you with some information tonight that guides you with the statute of frauds that I have prepared. And I will send that tonight along with the PowerPoint, so you will see that. But we prefer written documents. Reason being is because people can have what we call selective recall. There can be more confusion. And also, there is the statute of frauds, which require that certain documents be written to be enforceable. And we're going to talk about that in just a minute. But oral contracts are valid and enforceable unless they're illegal or violate the statute of frauds. All right. So it's going to be either illegal agreement or a defective agreement. So let's talk about written contracts. So in order for a contract to be enforceable, written contract, it must include all the terms and provisions of the contract under the statute of frauds. There are 6 agreements, types of agreements. Now, I'm going to tell you something that will help you remember it, and I'm going to send it to you. And it might not be in the order here, but it's, and I learned this when I studied for the bar back in 78, and I learned that it was my legs, MYLEGS. You don't have to remember it because I'm going to send you something that will be a chart to help you with it. And so M stands for contracts of marriage. Y stands for contracts that are a year or more. L is for land contracts. E is for executor contracts where the executor pays the expenses. G is for goods that are over $500. And the last one is suretyship. Suretyship is almost like insurance or protective, like a bond or something like that. So what it says here is that the 6 contracts that must be in writing to be enforceable, here it says contracts for real estate. What letter? What letter? What letter? What letter? Is that, what is that? Is that a I or is that a L? I can't tell. Oh, okay. L for land contracts. A contract that cannot be completed within 1 year. What letter? L-E-G. Yes. There we go. Y. 3. A contract to take on the debt of another. No. It's a bond, or either it's a bond. No. Suretyship. Suretyship. That's it. 4, a contract which an executor pays the debts from their own personal funds. You said that one already. What letter? There you go. That would be E. A prenuptial agreement. There we go. And then a contract for the sale of goods of 500 or more. What is that? What letter? G. So you see, if you remember my legs, it will help you. I scrambled these all around, and I'm going to send it to you with a little sheet. And excuse me, it's a benefit that only my students get when I teach this class, because that's how we studied for the bar exam for it. So it helps you a whole lot to cut to the chase. It eliminates a lot of confusion. All right. So if a contract does not exist in any of these scenarios above, the parties run the risk of the contract not being enforceable. Email communication has qualified under writing and under the statute of frauds based on a case, Luke Saint 4 versus Marie Lindy Santa Desire. So the court said the nature of the agreement along with the substance of various email correspondence found that communication met the elements required by the statute of frauds. I did not study that for the bar exam. We didn't discuss that then. Do you know why? Because there was no internet created in those years. But uh, so it's really cool to think about that. And I tell students that text messages and those kinds of things, voicemails, all of those can determine what a contract is. So, reflection question, and I'll leave that to you. How do you anticipate common law doctrines such as the statute of fraud to be applied in our future business environments? I think that based on the fact that we now have technology, it could be um, uh, very broad. And like I said, with the email communication and those kinds of things. Okay. All right. A little thought for you though. But you're going to be good with my legs. All right. Um, Little funny story. I ran into the person um, who helped us prepare for the bar a few years ago, and I said, "Hey, Mike." His name was Mike Spack. I said, "How you doing?" He said, "So forth." And I says, "He says you must have been one of my victims." I says, "Yeah, way back in 1978." He says, "Oh, wow." I says, "But let me run something by you that I never forgot." And he said, "What?" And I pointed to my legs. I said, he said, "Huh?" I said, "My legs." Oh, he fell out on the streets downtown, cracking up laughing. But it stuck with me, and I never forgot it. And while I was taking the bar exam, I had it a framework, not written down. I just remembered it. So it's pretty cool. Illegal contracts doesn't mean that every agreement entered into by parties is enforceable. For example, you can't enter into an illegal contract, such as, hey, I have a written contract to pay $10,000 to someone to commit a murder or to be a hitman. First of all, number one, that's criminal, okay? You're admitting a crime, accessory to a crime. So and then, by the way, if the hitman does the job and uh, they you don't pay them, do you think they'll file a lawsuit against you? Do you? You think they'll if you enter into a contract with a hitman to kill somebody, a written contract, do you think they will take it to court to enforce it? The answer is no. Somebody said yes because they didn't think about what I said, because then they would be admitting that they're a party to a crime. So, no. If the hitman fails to kill, you are not able to offer up the contract in court to make it enforceable. The contract itself is an admission of a crime, and you will be spending some time in prison. Typically, the courts will leave the parties where they were instead of enforcing that contract, except the law enforcement people will come and take them away and use that as an exhibit in a criminal case. Defective agreements can make a contract void or voidable. We're going to talk about that. Depending on error in the contract or the formation of the contract, sometimes defect can be one-sided, which is unilateral, or mutual, where both sides make a mistake. We'll get into that in a little bit. Third party, by the way, you'll see this in your materials. Third party and contracts. A novation, assignment, and delegation are ways in which a third party enters into a contract, where a third party, like for example, to insure property, that's where a third party, the insurance company, takes on the burden to protect it. As you maybe enter into a deal. As you know, when you purchase a house or a car, you as you get insurance. You get auto insurance, and you get real insurance on your property for two reasons: to keep from being sued, and then secondly, you also get it so that you can be assured that you are protected in a car accident or something like that. All right. So that's a little bit about that. All right. Next thing I want to talk about is illegal and defective agreements. Oh, okay. We talked about that. I think the basic elements of a contract. I need to backtrack. I kind of get that in for you. So the basic elements of a contract basically consists of offer and acceptance. But the nature of contracts and the classes of contracts is that, first of all, it has to be between two or more competent people to be enforceable or to be legal. All right. It must satisfy 5 required elements. It must be based on mutual agreement by the parties. Okay. Both parties must be competent. Can minors legally enter into contracts? Can minors legally enter into contracts? Yes or no? No, they cannot, because they are not competent. You're going to discover that. So if you as a minor enter into a contract with someone, or enter into a contract with a minor, another minor or adult, the judge will say the parties don't even have the capacity to enter into contracts. Don't you know that when you're a minor, you can get out of doing stuff, uh, but when you become an adult, then you're held responsible for it. You remember that? Yeah. Okay. So a minor is not competent, and in most jurisdictions, that is 18 years and above. The promise made by each party must be supported by consideration. One of the common ways of consideration is money, the amount of money, or the amount of services that are involved. For example, if you hire me as a lawyer to do something, the amount of money that I put in there is what you owe me for doing the service. But also, the consideration is my service. So I must provide my service properly according to what I'm expected to perform in that position. If I'm in a contract with you to represent you in a civil case, does that mean that I'm bound to represent you in a criminal case? Yes or no? That's right. The answer is no. The answer is no. Take that question mark off, because of the fact that that is not the thing that the parties agree upon. If they agree upon both of them, that's different as well. Then you have what we call contingent contracts, like, for example, personal injury cases, where you'll enter into an agreement to hire an attorney to represent you, and that you pay them if there is a settlement amount. If there is no settlement amount, you don't pay them. However, there usually is some language in there to cover the cost of paying for medical reports and other reports and other things of that nature. But you don't pay them unless that they get a settlement. You guys should all be familiar with that. The general number is 1/3 or 40%, depending on if it goes to trial. Um, it must be for a lawful purpose. We already discussed that. In some cases, it must be in writing. We already talked about that too, so because I had jumped a slide. So once these elements are established, um, we decide whether a contract, what type of contract exists, and then there's an article down here that you can look at, and you'll see that the Wang article. So you can take a look at that on your own. I'm not going to take the time to go over that, and the Clifford contract. So anyway, offer and acceptance. Excuse me. If a if a contract is formed, there must be a meeting of the minds. In other words, in order to have agreement, their minds meet. Basically, the parties are on the same page. Now, I agree to sell you a black car, and I describe the car. And then when it comes time to deliver the car, I try to give you a white car. That's an essential point because you entered into the agreement to get a black car. So it must be definite, the offer. It must be appear to be seriously intended, not jokingly. It must be communicated to the offeree. So if I communicated to you a black car, your expectation will be a black car, not a white car, unless the contract is modified by the parties, which does happen quite frequently. As you may realize that, like, for example, when you buy a house, you will make an offer, and then the seller determines whether they're going to accept that offer or counter offer or reject it. And then if they reject it or make a counter offer, you have a right to respond back to that until you two either meet the minds or the deal's dead, one or the other. So it says here, as we engage in more business dealings online, the concept of offer and acceptance can be muddled. Read the article below to see how offer acceptance is changing involving online. I can tell you guys that actually with the addition of online, it actually made it easier to do, but there are things that did take place, and that Wang article is a good article to help you get that information and understand that. Now, something I just talked about a few minutes ago, I missed this section: capacity to contract. One of the necessary uh, elements to enter into a contract is the parties both must be competent at the time of the contract formation. And then there are some persons who are not allowed to enter in the contract because of their age. We already learned that. They could be intoxicated at that time. They could have mental capacity problems, or check this out, in some areas, they are a convicted felon. Now, that is changing because it didn't make sense. It didn't make, so that means, in other words, if you're a convicted felon and you want to, start a new life and start a business, you cannot enter into contracts. It doesn't make sense. It's illogical. So anyway, that's an issue that is probably not going to be a problem anymore. Contracts involving minors are of particular interest, especially in entertainment. I used to be an entertainment attorney, an agent, and I represented a lot of athletes and entertainers. And we had some very interesting issues to deal with, not so much with the athletes, but the entertainers. We had big issues with dealing with minors. And for example, I had some dealings with the Michael Jackson family early on in their career, the music area. I dealt with some high school students who were heading to college, which now has changed a whole lot now because they can actually get paid. But I dealt with a few that were actual football players that are being drafted or free agents for professional sports teams. So very interesting thing. So consideration, we talked about that. The requirement requires that courts separate legal binding obligations from mere agreements by consideration, which is the price that a promisor, the person who makes the promise, or the promisee requires for a promise. All right, the amount of money or whatever exchange of valuable consideration. You will see, if you look at ever a deed in real estate, you'll see a statement something like this, that it says for good, no, for $10 or $1 and other valuable consideration the property is transferred, something like that. Have you ever seen that? You guys know what I'm talking about? Do you know what I mean? Either of you? No? Yes. And what that means, the further consideration is uh, what you pay. Well, once you once you buy your first piece of property or buy a home, you will see that. But you will see that um, what it means is that the dollar is a token consideration statement, but the other and further valuable is more of the value of what the service or item that you're purchasing. That's kind of like what that is, but it's some legal stuff there. All right, so now we've covered the basic elements, illegal and defective. And so the last thing is contracts between partners, ships, and other legal relationship. Now, in the operation of contracts, contracts can be involved with in, individuals, with partners, where there's more than one person, and we'll talk about that in a few minutes. And this could get really deep. When I took the bar, we had some real tricky questions, but because when I was in law school, I took a course, and the whole course was all about contracts with various entities, corporations, partnerships, sole proprietorships, and so forth, and the various types. So we're just kind of like just, as we say, scratching the surface here with this, because it can get so intense that it took us. I went to law school with semesters, which means that I was in class for at least 11 weeks or more. I think it was 12 or 13 weeks. But anyway, it was a long time. But we covered each of these areas. So anyway, the organizational operation of business is based on laws. There are written statutes. There's what we call um, uh, well, written contracts, written laws, written statutes, case law that determines. So let's talk about a sole proprietorship. Is the most basic form. It is something that doesn't require anything special filing or any other action. The sole proprietorship can exist in almost any industry. They are initiated by anyone with the proper ability, such as, for example, a lawyer can enter into a sole proprietorship, but they must have a license to do so. If the area requires a license, then they have to. But it is recommended to review all state and federal laws of any particular specialization. You're going to discover that we kind of shy away from sole proprietorships because the liability is something that can be um, held by individuals. Let's say, for example, I have a business and I'm a sole proprietorship, and I have a home, and you sue me about something that happened in the business formation. Well, if I am a sole proprietor, then unless there are some other things that are involved, you can have access and take my home from me. So it is a high risk area, high risk area. So it goes to many areas. And what many people do is they form corporations, limited partnerships, and things of that nature, which we're going to just kind of touch on. An individual selling goods on electronic marketplace, or a person offering lawn maintenance or snow removal can select the function as sole proprietorship. Now, with that, though, you probably want to get some insurance that will protect you from those kinds of things. And then you can enter into an agreement saying the extent of the liability possibly and limited the liability in the written contract. But a significant feature of the sole proprietorship is liability. That's what I was talking about. Sole proprietorships remain fully personally responsible for the debts and obligations of the company. So if bills aren't paid, they can come after your personal bank accounts, not your business bank account, but your personal. And the risk um, may seek other options of business development, including partnerships, limit liability and structures, and incorporation. Incorporation is something that we don't touch too much on in this course, but we will cover that before this course is over. All right, where people set up corporations. An individual can set up a corporation. That's what many lawyers, accountants, and other professions, you'll see something behind their name like um, um, a corporation. You'll see the letter R or something like that, which means they're registered. You'll see a small C in a circle. And when I was practicing law, many lawyers didn't do it, but then near the time I was moving out, people started to move towards protecting themselves with that. A partnership requires at least 2 or more persons. You can't enter into a partnership with yourself for engage in a for-profit venture. And it says voluntary efforts don't qualify as partnerships. It must be for profit. That's the key thing. Now, there's various jurisdictions that have what we call the Limited Partnership Act that control the organizations of partnerships. And it deals with the amount of monies. It deals with all kinds of things. It says in here, it talks about it in the 1990s. The Revised Uniform Partnership Act came about, and it has many features that are too many for us to cover here. But you'll see the information in your PowerPoints, and you'll see them in your book. So the key thing, just remember, is the sole proprietorship means what it says, one person. Partnerships is 2 or more persons. All right. So partnerships can be what we call general partnerships or limited partnerships. Again, this is very, very sketchy. What we're giving you in business law class, and I always tell my students this when I taught them, I said about business law that I'm giving you a working knowledge. I'm not preparing you to be able to understand it all. Just because you take business law doesn't mean you don't need a lawyer. If you're in business, you need a good lawyer, a good accountant, a good marketing person in these days and times. So a partnership can be formed on the basis of a written or oral contract, unless it fits in one of those categories, either expressed or implied, in which they join for business purposes for a profit. So the general partnership is governed by the Uniform Partnership Act, which has all states except one, Louisiana. A general partnership is an association of 2 or more persons who come together as owners. By the way, does anybody know why Louisiana is different? And generally, you'll run into issues with that state that you don't run into with the others. Well, let me help you. Most of our law is British based, from England. The Louisiana law is known for France and French. So the Napoleonic code and things is different, and it operates differently. When I was in law school, we studied, and I went to Northwestern Law School in Chicago area. Well, it was in Chicago actually, but you study the civil law generally of all 49 states. And the professor said, if you want to know about the Napoleonic Code and how it works in Louisiana, go to law school in Louisiana. The thing when you go to Louisiana, though, is you know how to operate in their state, but you have a disadvantage because if you go to another state, you're going to have a totally different system. And that's it. That's the only reason. That's it. So it's the origin of their law. Yeah, it is. It is. Yeah, I remember I was hired to represent a young man who got in trouble in a criminal case, And I told him, I says, I couldn't come to Louisiana unless you paid a whole bunch of money to me. And then I would have to work with an attorney in that state who was familiar with their system to represent that individual, because it's different. It's different. Limited partnership is two or more persons coming together under their state's limited partnership statute, with one or more general partners and one or more limited partners. Now, the key thing about uh, limited partners is limited partners are not held responsibly for the total amount of the debt of the company. Their liability is limited to their investment, and their participation in the business is limited. They may not even do anything except put money up. And so that's why they're there. They might have some say so about it, but on a daily basis, they don't operate and make the decisions of the business itself. So limited liability companies, or LLCs, and corporations involve documentation where you have to record things with the state. And there's the Secretary of State generally is the party that is responsible for taking care of those. So for more information, you can review this link, U.S. Small Business Administration. Again, those are just some of the things. We will be covering corporations, though, more in detail a little later. But just for your own information, be aware of the fact that a corporation is a person in itself, and we'll get into that a little later. All right. Any questions about anything that I've covered so far? Okay, very good. Again, I will make sure that you get the information about the statute of frauds, and you'll get the PowerPoints as well. So let's kind of like, I did go over week two assignments. No, I went over, I thought I did week 2. Let me go back again. I did go back week 2. Did I do that one right? You're right. You're right. Thanks for reminding me. Week 2 follows this scenario. And so you're going to make sure that you go over that information. So you've been hired as an advisor, and you're going to expand both physical and digital presence. The organization has 2 offers it received: purchase of real estate, a 5-year marketing agreement. And so what you're going to do is write a formal business memoranda that addresses the following. We've talked about these things. What are the basic elements you'd expect to find in each of these contracts? What type of commonly used contract clauses would you expect to use in these contracts? What business recommendations would you share with the company as it proceeds forward? Should it consider accepting the offers? And if so, what conditions would apply? All right. So basically, you're just using this scenario on what I just lectured you on today. Does that clarify or help you? Oh, you're welcome. Now, remember this. I should have got a clue when I saw that PowerPoint thing, but this one this week, I'm going to show you in a minute. It says a Word document. Remember I told you that you will be using a Word document. A Word document. Boy, I had a brain cramp. I'm glad you said that to me, God. I didn't even realize that. But it's important for you to understand that most of your assignments are going to be in Word. Let me go back now and bring you to the rubric for that, so we can make sure. Here we go. It's coming up. There it is. So what I told you earlier, all right, this is the column I want you to pay attention to. And then notice it requires explanation of contract, thorough and detailed explanation of the basic elements. You know those, some of those. You know more as you go through the reading. And then the second thing is explanation of clauses in the contract. A thorough explanation. Make sure that you have the recommendations, exemplary recommendations on how to proceed with contracts. And then the last part is make sure that you have citations in that body and references at the end. Now, I would recommend to you, it doesn't say how many pages, because sometimes it does, but I would figure that, by the way, it's APA, which means it should be a cover page, it should be a reference page, it should be citations in the body, references in the end. I think it's Roman 12 font size, but it should be double spaced, and it's important. Okay, but thank you for bringing that to my attention. Wow, that's that's, I guess that's trying to get started here. All right. Memorandum form is an essay form. A lot of students don't know the difference. You're still going to make full statements. It's not going to be bullet points, bullet points, bullet points. It's going to be a paper that you're writing. A memorandum is very simply a document that just lays it all out, but it's still going to be that way. Okay, got that? That is a good question, though. All right. So I covered everything. The discussion. Go back to that. Okay. So let's cover the proper discussion post. So you're going to deal with this information up here, and in your initial post, provide an example of a possible agreement that involves organizations and individuals. Housing, oh yeah, I did talk about that. All right. So those kinds of things. All right. Yep. Okay. Any other questions at this point? I'm going to give you something else. Okay. I will give you the key phrase just a minute. That's usually the question. But anyway, I'm going to show you how to use these flashcards. Remember last week I showed you how to do them. So this is your self-assessment. So you start it and you go through and you click. So what is a merchant? And then you can click over and it tells you a person who customarily deals in goods of the type involved in the transaction, one of whom the contract is in the course of the business. So, and then you can go to the next one, and you go through, and so you drag the card to the right and be able to get this done so it's correct. All right, mirror rule image. We didn't talk about that, but it's in your reading. The common law rule that states the acceptance must be on the same terms as the offer. In other words, a meeting of the minds. So that's that. So you go through each of them and you will be able to do it. All right. So those are good practice tools for you. All right. So I am going to give you a key phrase. It's one of my favorites that I like to use for this module. Anybody have any ideas? You can type in the chat box if you do. Going once, going twice. final. I'm not going to type it in the chat box because nobody will see it, because usually in the recording you don't see it, but I will say it out loud. Statute of frauds. That's it. Give me that. And then again, I will be sending you the information. Uh, my legs. That's a good one. Or my name. No, I don't think I've ever used my name. Uh, but statute of frauds. All right. So, well, guys, I'm going to say good night to you. And again, if you want, you can go into the little link and you can put your key phrase in and get your points right now, right after I sign off. So you'll have it in already, but make sure you get it in by Sunday. All right. So enjoy the rest of your week and stay safe. See you next week, next Monday. Oh, you're welcome. Have a good one.